Hey everyone, David Tarras from the Rossen Law Firm, head of our federal criminal defense practice. Continuing our series in today's videos on PPP, Paycheck Protection Program fraud. One of the biggest frauds in United States history. The Department of Justice is cracking down now more than ever since this program was initiated in 2020, because there are still billions of dollars outstanding that it still needs to be paid out to individuals. And right now is the time when a lot of individuals who requested a PPP loan are going back and trying to have their loan forgiven, because the PPP loan is one of the loans that was offered during COVID-19 that is allowed to be forgiven if spent properly. What we're going to talk about in today's video is, what does the court process itself look like on a PPP fraud case? Now, we talked about the investigations. You might have received a target letter. You might have been voluntarily approached. It doesn't feel so voluntary, but what the government would consider a voluntary interaction or encounter with you, a phone call or coming to your door, speaking to you and asking you questions. You might have received a subpoena. Your bank account might have been frozen, which we know behind the scenes is the government freezing your account to look at your records, which we've already talked about in our previous series. So now we're going to talk about what happens if you have actually been investigated and the government has decided to go ahead and prosecute you. Now, in a previous video, we also spoke about the different charges, or the most common charges, the crimes, the penalties, and the elements of each of these charges. And specifically, we're focusing on wire fraud, bank fraud, identity theft, and money laundering, with wire fraud and bank fraud being by far the two most common when it comes to PPP fraud in general. And then we also see these aggravators that the government tries to tack on for identity theft, only in certain cases, money laundering in a lot of cases, and these all directly affect what your potential exposure is and why it is so important that you need to contact the Rossen Law Firm to help you. So let's say the investigation is finished, and if you hired us early enough, we will be in communication with the government, with the prosecutor who is looking to bring charges against you, to either negotiate charges early or to say, go to your grand jury, we're going to fight this all the way. Every case is different. But let's say you are charged and the prosecutor decides to charge you. Well, the first step, once the prosecutor goes to a grand jury, they will present your case, and they will, if they've already gotten to this point, receive an indictment from a grand jury, which is nothing more than a rubber stamp. If the government brings it, if the federal government brings the case to a grand jury, they're going to get their indictment. It might not be for every count they wanted, but they're going to get it. So what do we do at that point? When you're charged with PPP fraud, one of the crimes related to PPP fraud, the first thing that's going to happen is you're going to have an initial appearance. Initial appearance is a crucial first step, because that is when your bond is going to be set. If you have a defense attorney, if you have an expert in this field, in this practice area of complex white-collar litigation, like myself and the attorneys at the Rossen Law Firm, we will know that the best thing to do is for us to get on board early enough so we can pre-negotiate your bond before we step into the courtroom for what's called your initial appearance. In state court, it's called first appearance. This is when you go in front of a magistrate and we make recommendations, an argument regarding what the terms of your release should be. If you hire an attorney early enough, why it's so important to be proactive is because we can negotiate that ahead of time with the prosecutor, so that initial appearance is very smooth. The best thing that we want to try and go for is what's called a personal surety bond or a signature bond, and we at the Rossen Law Firm have a very high success rate. Every case is different, but we have a very high success rate of coming in early enough so we can negotiate a signature bond with the prosecutor, so that when we go and meet with the magistrate that morning, it's recommended to the magistrate, and the magistrate will very likely follow our recommendation that you just sign and swear that should you violate the terms of your release, then you're responsible for some sort of monetary payment. Otherwise, it's just a signature. So it's super important to hire the best counsel prior to your initial appearance. The next step is what we call arraignment. If we have been retained on the case, we will go to the arraignment, and what happens at arraignment is we enter a plea of not guilty. We always enter a plea of not guilty at arraignment, and that is true even if we might have been retained very early in the case, or the evidence might appear to be overwhelming against our client, and we may have worked out an early and favorable plea negotiation prior to our client being charged, which is something that can be done and is sometimes very effective, a very effective tool that we use in the defense of our clients so that they can achieve their best futures. Even if that's the case, at arraignment, we enter a plea of not guilty. We demand a jury trial. Now, not every case goes to jury trial. Most of them don't. But we still demand a jury trial in these PPP fraud cases because we want the discovery. We want the evidence. We want to see what the government actually has. A lot of attorneys in federal criminal defense, and as they relate to as specifically as it relates to fraud and PPP fraud, which we're dealing with here, they're going to say, well, what do I need the discovery for? I've already spoken to my client and we've decided that the evidence appears to be overwhelming. We're going against the United States government. They're so powerful and they're so strong, we're screwed. That's not the case. Even if we do have early negotiations and it appears that we're already on a path to resolving the case via a plea negotiation and a sentence, we need to see the evidence. It is completely unacceptable for any attorney not to at least look and see, is there something that we're missing here? So at arraignment, we demand discovery. The judge requires the federal prosecutor to give us the discovery because we never want to rule anything out. We want to overturn every stone in your case as it relates to PPP fraud, whatever charge or whatever crime might be associated, whether it's wire fraud or bank fraud, and we want to fight for you. And the fight is never over. The fight is not over even if we all advise or we decide as a team with you and us to say, let's enter into an early resolution. We made a mistake. The evidence appears to be overwhelming. We still have to explore it all, and we have to explore it all with you. So we have to enter a plea of not guilty. After that, the case is going to be set for something called a calendar call, usually 30 to 45 days after the arraignment. At the calendar call, we're going to have reviewed the discovery with you. Sometimes the discovery in these cases can be hundreds of thousands, sometimes millions of pages of documentation. The judges will give us time. Federal cases do move quicker than state court cases. We'll have a first calendar call. If we're not ready for either a plea or a trial at the first calendar call, then we'll request a second calendar call. Basically what the calendar call itself is we go and the judge will ask, are the parties ready for trial, or would you like like for me to set the case for a plea? Is there a plea that's already been negotiated? Every case is different. If we're on a trial track, we might be ready by the first calendar call. It's pretty rare, but it's possible. Usually we're going to request a second calendar call to continue filing motions. We're a very motion-heavy firm. We beat a lot of cases with motions, even against the government, which can appear overwhelming to so many other lawyers. We fight these cases, and we fight for you. After calendar call, a judge is going to, at that point, expect the case to go to trial or to enter into the process of plea negotiations. In a future video, we're going to talk about how plea negotiations work as it relates to PPP fraud cases, whether it's wire fraud, bank fraud, the two most common sources, sometimes mail fraud as well, but essentially fraud with minor distinctions in these offenses, in the elements which we will discuss in another video. But at the end of the day, we have to work together as a team. We have to have reviewed all of the discovery in the case to make a decision about whether or not whether help you make the decision, because it is our client's decision, but a team effort to decide after weighing all the pros and cons whether we should enter into a plea agreement or go to trial. Now, if we go to trial and our client is found not guilty, it's the best feeling in the world. We walk out together, nothing on your record, everything is good, fantastic result, the best result, okay? Majority of federal cases do not go to trial. somewhere around 98% of cases resolve via a negotiated plea. So we have to always be keeping in mind the possibility of, even if it's just in your best interest, limiting your exposure. But we never rule out the possibility of a trial. We never just assume because 98.5% of cases plea that yours must plea as well. Every single case that we handle at the Rossen Law Firm is specifically tailored to you, especially as it relates to PPP fraud, because the pandemic caused so much, and rightfully so, so much hardship, which also led to hysteria. People lost their companies. People weren't able to pay employees. People rushed to get this paycheck protection money from the government. And some of our clients did cut corners, okay? But that does not mean that they are a criminal, okay? There are defenses, and we're gonna have a whole other video on the specific defenses to these charges in question. But don't give up. Don't say just because you might have said you had 6 employees and only had 2 that your case is over, that you've committed fraud and you're going to prison. Be proactive, contact the Rossen Law Firm, let us go through your case. Let us go through the government's case in detail with a fine comb and see, is there actually enough evidence to get a conviction beyond and to the exclusion of all reasonable doubt. So we can never rule out the possibility of trial, but again, pleas are very common in these cases, and it very often becomes a matter of how much exposure are you looking at? How low can we get your exposure, your potential probation, house arrest, or potential incarceration period under the United States Sentencing Code, and more importantly, under the United States Sentencing Guidelines. In a future video, we're going to be breaking down specifically how the guidelines work, the common outcomes, not only for our own clients, but the outcomes that we at our firm track around the country in the realm of Paycheck Protection Program fraud specifically. Stay tuned.